Thank you. I am the last paper before the discussion, which means my job is not to hand you a 10th finding on top of the 9 you already have. It is to hand you a vocabulary for the argument you are about to have for 45 minutes. Here is the claim in one sentence. Language AI is not a mirror held up to legal reasoning. It is a subtraction instrument. It runs the practice with one variable absent: anticipation. And what breaks under that subtraction tells you which parts of legal reasoning were ever load-bearing. That is a finding about the machine. It is also, and this is the uncomfortable half, a finding about us. The question that convened us asks whether language AI automates the inessential, or whether it reveals that legal reasoning was always statistical. Both answers have been well defended here. Sharma gave us proportionality as Bayesian optimization. Papastavru asked whether law is structurally computable. But notice what the two poles share. Both are claims about the nature of the tool. Both place the observer outside the observation, looking in. The second order move is to turn the instrument around, not what is the AI doing, but what does the instrument reveal about the observer holding it? This is neither vindication nor indictment. It is observation of observation, and it changes what counts as evidence. The metaphor doing most of the work at this conference is the mirror. It is a generous figure, and I do not want to be ungracious about it. Papastavru's version is careful, but a mirror only reflects what you put in front of it. It cannot tell you which part of what you put there was doing the work. Subtraction can. Here is the operation. Language AI performs legal reasoning with anticipation absent. Where the output stays serviceable, the memo passes, the analogy holds, the exam answer scores, the practice was pattern. Where it fails, anticipation was load-bearing. Now the caveat, and I would rather say it than have it said to me, this is not a controlled experiment. Nothing was removed from anything. These systems were never anticipators. There was no anticipation in there to take out. What I am offering is an as-if subtraction in Weihinger's sense, a fiction that earns its keep entirely by what it lets us localize. If it localizes nothing, throw it away. Which requires one prior commitment: orthogonality. Computational capability and existential capability are independent dimensions, not two ends of one scale. Two consequences, and they cut both ways. High benchmark performance is not evidence for anticipation, and failure is not evidence against computational competence. So when Nagel replicates Lexam, or when Joel Niklas's benchmarks measure legal reasoning with real precision, they are measuring the horizontal axis beautifully, and they are silent on the vertical one. That silence is not a defect in the benchmarks, it is a design feature. They were never built to detect the thing. Mistaking their silence for a null result is where most of the mimicry debate goes wrong. So what sits on the vertical axis? Not prediction. Prediction extrapolates a pattern. Input weights output. That is the left-hand side of this slide. Anticipation is acting now on a model of yourself in the situation being modeled. Rosen's modeling relation. The formalism I use is psi congruent to M, structural isomorphism, and deliberately not identity. And the operational test is this. Understanding requires the ability with consequences to question the ground that gives a representation its meaning, the Fundirung, the thing apart for whole stands on. With consequences is the load-bearing phrase. A consequence is an intervention in a model of the world. It is not an inference inside a formal system. A system confined to inference inside the formal system can be highly effective and still be unable to say why this intervention rather than the alternatives, because it never had standing to put the alternatives at risk. Anticipation is not one faculty. It is three acts in sequence, each held up by a different enabling constraint. Every one of the three has been on this program. Abduce, generate the candidates at all. The constraint is exformation, what was shed from the representation. Genta on outsourced analogies is about this. So is Gur-Aryeh on the collapse of indeterminacy. Interpret, determine what the candidates matter for. The constraint is valence, what is at stake and for whom. Londano on choosing how to interpret. Mohiki on hermeneutics. Decide, commit, and become answerable. The constraint is affordance and habitus, position, standing, exposure, Capriati's machine judge, Saran and Posner's agents before the Seventh Circuit. The three share one object, the alternative interventions. Those alternatives are attended to as ifs, and each has to be abduced and then interpreted before anything can be decided. And here's the part to hold on to. Remove the enabling constraint and the act does not degrade gracefully. It stops being that act. What you get instead is an artifact that resembles the act's output, which is precisely what makes it hard to see. Which brings me to what I think is the most consequential finding of these 2 days. It is not hallucination and it is not bias. Left panel, discarding with a trace. A lawyer generates a hypothesis space, selects a path, and the rejected alternatives go somewhere: a file, a memo, a colleague's objection, a footnote in an opinion. You can go and ask. Right panel, the candidate set arrives already compressed. Interpolation inside a compressed space looks exactly like determinacy, and the shedding leaves no trace, not merely that the alternatives are gone, but that the fact of a shedding is gone. So I would put this to Gur Arya directly, and I mean it as a friendly amendment. Legal indeterminacy has not collapsed. It has been exformed. The absence reads as convergence. And notice what that does to accountability. What counts as a live alternative is always relative to a distinction somebody drew. Under exformation, nobody drew it. There is no one to ask. Now, the half of this that costs law something. Wherever the subtraction leaves output intact, and over 2 days you have documented a great many places where it does, law's self-description as propositional and rule-governed was ornamental. The facade. The operation underneath ran on pattern recognition, analogical clustering, contextual weighting. That gap is not new, and AI did not create it. The legal realists were on it a century ago. What AI did was make the gap too expensive to keep denying. And it puts a sharp point on reason-giving. Himes' paper. Disclosure regimes ask for the salient rationale. Why this outcome along the path taken? That is a how. Legitimation needs something else. What was discarded? And on what ground? That is a why. We routinely conflate the two registers, and only the first is ever required. An explanation that supplies the how, while the why has been exformed, is not partial transparency. It is a different object wearing transparency's clothes. One clarification before I stop, because this is where I get misread. None of this is a claim about biology. The boundary that matters runs between anticipators and non-anticipators, and nothing reserves the first category for carbon. My claim is that current systems do not care. No valence, no exposure, nothing at stake in the future they describe. That is a claim about what has been built. It is not a ceiling, and I would be foolish to defend one. Which is rather the point. If someone builds a system that genuinely occupies the position, the boundary moves and this analysis moves with it, because the analysis is written on the act, not on the substrate. So 3 things to argue about, and then I will stop and listen. First, the orthogonal test. Of everything presented in these 2 days, which findings measure computational capability, and which are claims about anticipation? My honest count is that several papers move between the two without marking the transition, possibly including this one. Second, if indeterminacy is being exformed rather than resolved, what would a duty to preserve the discarded actually require of a court, a tax authority, an agency? Third, and this is the one I would most like to hear you on, whose self-description took the greater damage this week, the machines or ours? Thank you. I will leave this slide up.